Welcome to Packet 3. Packet 3 includes forms for dissolution of marriage with property. And as you can see in the list, there's only 3 forms, which is the major dissolution of marriage, and then we have marital settlement agreement and the final judgment. So we will begin with the initial form. The first form is for petition for dissolution of marriage with property but no dependent or minor children. And this is if you have assets and liability to divide, but you don't have children. If you have children, there's a separate packet 2 that involves property and children. The first section includes all the instructions that we will just skip, and you could always refer back to it if you have any questions regarding what we discussed today. So the first form is the petition. And like a lawsuit, divorce is like a lawsuit. So you have to file forms that are required to file, which you should have completed with packet 1. And this is the petition. The petition is the actual form that is seeking the divorce. And what you're saying, court, take some action, i.e., grant me my divorce and divide property. So what we're going to do is we're going to fill out the top like usual. When you did packet 1, you had to list the circuit, the county, the name of the petitioner. If you are filing the divorce, you're the petitioner. If you're responding to the divorce, you're the respondent. So if you're filling this form out, you should be the petitioner. Case number, you're going to leave blank, and division, you're going to leave blank. What will happen is once your case is filed, the clerk will fill that part out. And as suggested, this includes dissolution of marriage. So you as the petitioner has to write your full name, and we'll go over each section. So 1 deals with the jurisdiction. And as we mentioned, you have to be a resident of the state of Florida for at least 6 months before you can file for divorce. And it doesn't have to be just you and your spouse, or your spouse only. So you have to check whichever one applies. Next section is whether you are members of the military. You're going to check whichever applies. And the marriage history. Next is a marriage history. Marriage history is the date of marriage, date of separation, and place of marriage. The date of marriage is the date you got married. If you only know the month and the year, that's fine, as long as you get some idea of it. Date of separation. Date of separation is if you two separated or decided that you don't want to be married any longer. In the state of Florida, there's no legal separation, so the date of separation is not that important, but you can list it if you want to list it. And then next is the place of marriage, where you got married, the county, or if you have married in a foreign country, you're going to list the country. And number 4, as we mentioned, you're saying that there are no minor children under the age of 18. That's what minor children are. And then number 5, you're saying you file a notice of social security number, which we did, and it was in your general form. And 6 asks about why you want the dissolution of marriage. Normally, it's always the marriage is irretrievably broken. Oftentimes, Florida is a no-fault state. So you could get divorced for whatever reason, so it doesn't matter. Second part is whether the other party has been mentally incapacitated. That's only if there's a court order that says the other party is incapacitated. So and you have to attach a copy. Well, otherwise it will be the first part. So section 1. What we're going to discuss is the marital assets and liability. Assets are things of value that you own, and liabilities are things you owe. So marital assets are anything that you accumulated together during the marriage. So if you bought a house together, bought a car together, you opened a bank account, you have a CD, you have liabilities are the opposite, like any loans you have, if you have medical bills, etc. Those are liabilities. Credit card bills are also liabilities. So this section is saying how you want to resolve those assets and liabilities. 1 is saying there are no assets and liabilities. What that means is you're not wanting to divide anything. There's nothing to divide, so there's nothing to consider. So you check 1. Again, this is only if you don't want to divide anything. You have yours, he has his, and then everything's fine, and you just want the divorce. Then you'll check 1. If that's the case, you might want to do simplified dissolution. It's up to you, but that's another option. Second part is if there are assets and liabilities and how you want to divide them. So you could do it through a marital settlement agreement, which is a form that we'll go over next. But basically, marital settlement agreement is saying, hey, we've agreed to how we're gonna divide everything. So court, here it is, we've both agreed, so we want the divorce to be granted. You could agree to everything, meaning how everything is gonna be divided, or you could only agree to part of it and then say, we only agree to this part, we haven't agreed to this part, so court, please decide the other part for us. It's up to you. And B is saying, we haven't decided anything, so we want you to decide for us. The state of Florida is an equitable distribution state. So what that means is everything is divided 50-50 unless you could show something else. So if you could say, I know it should be divided 50-50, but I should be able to get X, Y, and Z because, and you have to show a reason why. I contributed to it, I helped make it more valuable, so I should get a portion of it. Those are some excuses, but you could write whatever works best for you and say why you think you're entitled to it. Okay, and then the next section is spousal support. Spousal support is called alimony, so I will call it alimony from now on. So alimony is basically money that you get to help you live. And it is determined three ways. One is based on the duration of your marriage, meaning how long you've been married. Two is whether you have a financial need, the person asking for the alimony has a financial need. And three, whether the person that's going to pay it has the ability to pay. And what that means is, yeah, I might have a financial need, but if he doesn't have the ability to pay, the court may not grant it. An example is, let's say I make $100,000 a year, my spouse makes only $30,000 a year, and I'm like, I have a need, I want alimony, but the court will look at it and say, yes, but you make a substantially more income, almost 3 times more, so how do you have a financial need? Having credit card debt is not a financial need. You have to have some type of need that goes beyond just accumulated debt. So that's what they look at. And the court looks at how long you've been married. In the state of Florida, 20 years and over is called long-term marriage. So you have more likely than not of getting alimony. So 10 to 20 years is medium. So, and 1 to 10 is considered new. So based on the duration of the marriage, the court may grant more or less. And again, the reason why they look at the duration of marriage is if one party left a good career, made some sacrifices so the other party could thrive, then they look at that to determine whether that party has the need to get the alimony. Okay, so if you check 1, you're saying I give it up, meaning I don't want it, so I never want it, and I'm giving it up forever, which means you can't come back a year from now, 5 years from now, and say, oh, you know what, actually I need alimony because I lost my job and he has the ability to pay. Once you give it up, it's forever and you can't come back and change it. So if you think you might need it, I would always recommend asking for a nominal amount, and you could always go back in the future and ask for it to be changed. But to change it, there has to be some substantial change in circumstances. 1, I lost my job, he got a raise. So then you could say, hey, there's been a substantial change in circumstances. I know I was only asking for $100 a month, but I lost my job and he's making so much more money, he could afford to pay me, and the court will consider it. So you have a better opportunity. So you could say you could ask the other spouse to pay, and you could be any other time. If you have a figure you think, you could write that figure in. If you don't have it, just write a reasonable amount, because what the court does looks at that, but they have a calculation that they go through, and you are not expected to calculate it at this time. So the court may look at it later in the future and come up with a figure. They look at your income, his income, and whether how long you're married and how, expenses. If he has like child support to pay, the alimony comes in second. So those are the things you have to look at when you ask for it. And you could ask for it however it's paid. And it's continuing until X period. In the state of Florida, they no longer have permanent alimony, so it's limited to temporary, bridge the gap, duration, rehabilitative, and lump sum. Temporary is for a short period of time, just until, let's say, the divorce is over, and then once it's over, I could get more money. Bridge the gap is, hey, so that I could let's say I was making this amount of money, I quit my job, but now I'm making this amount of money. I need the extra money to bridge that gap. Duration is for a certain period of time, 5, 6 years, however long you want, 10 years. Again, you have to show why you need that money. Rehabilitative is I quit my job when I got married. My skills are no longer good enough. I have to go back to school. So I need help while I'm in school. So they could give you that money. I'm disabled now, but I should be better in about a year. So I need money to get better, things like that. That's what rehabilitative is. And lump sum is give me X amount of money right at the beginning and I won't ask for it anymore. It ends with that lump sum. And oftentimes it's used as a form of dividing assets or substitute for assets because there's some tax benefits or tax detriments to paying alimony. So you have to talk to the tax attorney, but it has some impact because it could be considered income for the person receiving it, and it could be expenses for the person paying it, and it has some tax implications, so you would have to take that into consideration. All right. And number 4 is asking about life insurance. So when you get alimony, if alimony is granted, it's for a certain period of time. If your spouse passes away, that ends. So you can't get any more alimony. So if you have the other spouse get life insurance until you're supposed to receive your alimony, if he passes away beforehand, then you're protected in getting some money if he passes away. And I would say generally the court will accept it as long as it's a reasonable amount of money. Like if you're getting $500 a month, you could ask for $50,000 life insurance. So as the beneficiary, just in case he or she passes away. So that's what section 4 is. Last section, actually second to last, other, is if you want to change your name, if you were married, if you're a female and you were married, I guess it applies to males too. If you took your spouse's name when you got married, you could ask for the court to change it back to your maiden name through the dissolution of marriage. And what that does, it gives you a court order you can use to say, I got my name changed, so change my DMV license, change my social security card, change my passport, change all the things so that I go back to my maiden name. I would recommend that if you think you want to change your name, to do it right now through the divorce, because it will save you a lot of time and money. Because let's say you didn't do it, and then 5 years from now, you're like, oh, I should have gotten back to my maiden name. Now you have to file a separate court action. That's another filing fee. And if you hire an attorney, that's another attorney's fees. Or even if you do it yourself, you have to file it through the court, get your, fingerprints and all that stuff. And that could take time and money. So if you get it now and you don't use it, you could use it at a later time. Let's say, all right, I'll hold on to it now. I don't need to change my name now, but in 3 years, in 3 years, I'll say, hey, you know what? I should have changed my name. Oh, I have the court order. I could go and do it now. So that's how it works. So I always recommend if you think you want to change it, get it while you can. And other relief is things that were not included in the dissolution of marriage. You could say, hey, we have a dog that we need to have time sharing with. Unfortunately, dogs aren't considered children, so they won't do anything. They're considered personal property at this time. Who knows, it might change. So you could ask it through the other relief about how it's divided, who gets them, if you want a time sharing. We've had cases where one spouse got time sharing with the dog for the other spouse. So it's always up to you. If you don't have anything, leave it blank. And request, this is the summary section. So this is where you write everything you requested. So you're saying you want the dissolution. Did you have any assets? If you didn't, leave it blank. If you had alimony, leave it blank. Restoring name, leave it blank. If you ask for it, you're going to have to check it. So, oh yes, I want my name changed. Yes. Do you want alimony? Yes. Do you want to distribute marital assets and liability? Yes. So you would check whichever one applies. Next section is whether you're affirming to the truth. And this form has to be notarized in front of a notary. So do not sign it until you get in front of the notary. Show your ID and then they will notarize it and then you can sign it. So that is make sure that you say you're telling the truth. And it's a petition and affidavit, so you're saying everything you've included in there is the truth. Okay, so the next form we have is the marital settlement agreement. This is only if you both agree, your spouse and yourself both agree to resolution. Remember I mentioned earlier that you could agree to part of it or you could agree to all of it. It depends on which one, but you both have to agree to fill it out. Again, this is just some instructions. You could review. If you don't want to, you could throw it out. So this is the actual form. And as you can see, you both have to sign it. We, the petitioner and the respondent, agree to X, Y, and Z. So you're saying that the marriage is broken and you want you've exchanged the financial affidavit and you're agreeing to how the assets are divided. So you have division of assets. The petitioner gets X, Y, and Z, everything. You got to list all the things the petitioner gets, right? And then the respondent gets whatever else. And then you got to list everything the respondent gets. And then any liabilities that you have. So who's going to pay what? So you could divide it. And then the respondent has whatever liabilities. So this includes all the things that you could divide, okay? And then it goes into why it should be divided. And then you go into spousal alimony if you agreed, how much you agreed on, etc. And then you both have to sign. See, this section is for you. You have to get a notary, and the other section is for the party. So if you don't think the other party is going to agree to anything, throw the form out. You don't need to even fill it out. It's only if you both agree. Okay? So the next form is the final judgment. This is the actual document that grants you the divorce. So once you go to a hearing, once you go, if you agreed and they agree, the court accepted the agreement, if you went to mediation and the court accepted the mediation, you went to trial and the court said, I divide X, Y, and Z, the court will fill out this form. So all you have to do is fill out the top and leave everything else blank. The court will fill out every other section. You see, the court will be the one that divides everything, who gets what, how much, and then if there's going to be alimony, etc. And then in the end, how it's going to be paid. See, there's a lot of things, and the court will sign the end. And once it's signed, normally it takes a couple of weeks, if not sooner. If you have email, it might be even sooner. The court will sign it and send you a copy of the form. So once you get this form, you are officially divorced. Although you're at the hearing and the court say, I grant you the divorce, it's not valid until you get this final judgment. So you have to have this final judgment to get divorced, and you have to wait a waiting period, approximately 30 days. Normally, if you agree to everything and everything's okay, then you should be fine. But if there's some dispute and if the other party appeals it, then you are not divorced until the appeal is finalized. So just be aware. So that's all I have. And thank you. And you could go to the next section regarding service of process.